My name's Cameron Crease. I work at Collyer Bristow and I am an associate. Lasting powers of attorney, or commonly abbreviated to LPAs, were introduced in 2007, and they are the way in which people can give others the authority to act on their behalf, particularly in the event that they lose capacity. There are two kinds of lasting powers of attorney: property and financial affairs and health and welfare. To start with the property and financial affairs, this, as you can imagine, permit the attorneys to buy and sell property, investments, and even actually make gifts on behalf of the donor. Without having that in place, it would be very, very difficult, and in fact, a lot of the time, assets are frozen without having an LPA. So even, for example, joint accounts, jointly owned assets, can be frozen sometimes. These property and financial affairs can be put into place and are effective unless the LPA specifically says otherwise from the point at which they're registered, which gives the attorney power to act even when the donor still has capacity, which can be very, very useful. But it goes to the absolute core of these lasting powers of attorney, which is to choose someone whom you trust. The health and welfare lasting powers of attorney, again, you can imagine, goes to making decisions about someone's well-being. So it goes to, their diet, where they live, and how they live as well. And unlike the property and financial affairs, those aren't effective until the donor loses capacity. In the event that those aren't put in place, you are not able to make those decisions on their behalf, and instead it goes to the decision of medical advisors, so doctors and social services, to make those decisions. So effectively what you're doing is putting the best interests of the donor in the hands of the people that know them best. One of the big decisions is life-sustaining treatment, and a lasting power of attorney for health and welfare actually has within it whether or not you can give your attorneys the authority to make that decision on your behalf. That's probably the most profound choice really anyone can make for someone. So we're talking about DNRs, basically. It's commonly misconceived by lay people a lot of the time as to what capacity actually is, whether or not somebody has capacity to make a lasting power of attorney. For example, just because somebody doesn't live independently anymore doesn't necessarily mean they don't have capacity. With lasting powers of attorney, there's somebody called the certificate provider, and that's usually either somebody who's known the donor for a long period of time, or a professional such as lawyers, or if capacity is in doubt, it's quite useful to get doctors and to get medical opinion as to whether this person has capacity. And lawyers, and particular doctors, can make that decision and will sign the lasting power of attorney. Unless it specifically states otherwise with the property and financial affairs, we would always recommend that the lasting power of attorney, as soon as it's registered, provides the attorneys with the authority to act on the donor's behalf. That's because sometimes the donor simply can't go down to the bank and get cash out, or whatever it might be. They might be incapacitated physically, not mentally incapacitated, which is obviously a different thing. Say you have the flu or something and you don't want to go down, especially in the modern age. You wouldn't want to go down to the bank, and instead your attorneys can have the authority to do that, unless it states otherwise in the LPA. The fundamental thing to remember with lasting powers of attorney is to choose someone who can act in the donor's best interest. So it's no good choosing a stranger. You want someone who knows the donor and can make the decision on their behalf. Usually, of course, it's the spouse or the civil partner, and the children potentially, or a very, very good friend. It might be helpful to note that multiple lasting powers of attorney for business and property can be made, and you can have different attorneys for different purposes. For example, a business power of attorney, so that instead of having your spouse or civil partner as your attorney, you can have your business partner. The donor can specify whether the attorneys, if you've got more than one, can act jointly and severally, or just jointly. So they will either have to act together and agree together, or they can all act in their separate entities on behalf of the donor. Of course, for the sake of harmony, you would want to choose the right people that get along with everybody. But as I said, it's fundamental to the donor to pick someone who's going to act in their best interest. If there's rifts going through a family or between friends or whatever, and somebody appoints that person rather than that person, there should be good reason. And one would hope that it's plain why you've chosen X over Y, because these decisions to make a lasting power of attorney and the decisions that you're bestowing upon your attorneys are very important, and it's important to make the right decisions on the donor's behalf as well. If the donor has had capacity and that's been documented, if there's any doubt, you might want to get a medical report to substantiate the fact that they do in fact have capacity. It's very, very difficult to challenge it. In fact, it's almost, I think, impossible. Here at Collyer Bristow, we can collate the information and prepare the lasting powers of attorney, submit them to the Office of the Public Guardian on our clients' behalves. Usually we provide this service alongside our will service. It works nicely in tandem with each other, your wishes towards the end of your life and then afterwards as well. We can obviously provide guidance as to who you might wish to choose, who seems like the appropriate person for you, acting in your best interest. But as I said, you have freedom to choose who you like. It's usual to choose spouse or civil partner, maybe children, or a very, very close friend, but you have freedom to choose who you like. The donor, while they have capacity, can revoke the lasting power of attorney and appoint someone else. Once they lose capacity, it becomes much more difficult. It's something that happens infrequently because usually there's so few people that broadly people might trust with these kinds of decisions that they make the decision once and that's it. But it can be undone. We specialise in getting to know our clients and knowing them well and understanding their wishes. It's about tailoring our service to you. And of course, with lasting powers of attorney, it's almost as personal as it gets. It is about making sure that it's done properly and you've chosen the right people so as to protect you for the future, for whatever unknown might be around the corner.